Welcome everyone, Costin here on Serious Gaming with a new discussion video. I want to talk about two important things. Net neutrality in the United States, which officially ended on a federal level, though there's a lawsuit to prevent that, to revoke that decision, reinstate the previous rules, and also the proposed European Union copyright law changes in the much dreaded Article 13. I'll start with the European Union changes and what the problem is exactly, because I got accused in the previous video of peddling conspiracy theories. Let me put it in a very simple way. What people are afraid with regards to the European Union copyright changes is that what the European Union wants to do is implement an internet-wide content ID system. Automatic bots that would filter content based on copyright on the internet. And as someone who's been working on YouTube for over a decade, I can tell you this, that it was a nightmare, and it still is a nightmare, to deal with the content ID system that Google runs. If anyone thinks that the European Union understands how this works, understands the internet, understands how much of a nightmare this would be to apply to the entirety of the internet, to all websites on the internet, to websites that do not have, by the way, the resources that Google has, then they are fucking idiots. The reality is there would be a real struggle for websites that have the resources, that have the capability to handle it, to even deal with it, and more likely is you will have a lot of non-European websites potentially blocking European users from using them. We've already seen that to a limited extent with some of the new changes that the European Union imposed, like the LA Times, Chicago Tribune, and other websites being blocked in Europe because they do not want to deal with the changes that are made, though they're saying they're looking at solutions. This would vastly increase the number of websites that would block access to European users. That's what I mean and what I meant in that the European Union proposed changes would kill the internet as we know it. Of course, this would only apply to European Union members. The internet would just be fine, well, notwithstanding the death of net neutrality in the United States, but it would be fine outside of the European Union. And let me read an article from Ars Technica, a respected website that's been around for quite a while. Illegal memes, weak safe harbor, unpacking the proposed European Union copyright overhaul. Overhaul would bring chilling effects, costs, and legal uncertainty along for the ride. Modern copyright rules fit for the digital age is how the European Commission describes its proposal for the first major overhaul of European Union copyright law since 2001, but a wide range of startups, industry, academic, digital activists, and human rights groups believe that key elements of the proposal will cause serious harm to the functioning of the internet in the European Union and beyond. A vote taking place next week in the key European Parliament jury committee will determine the likely shape of the law. The most contentious element is Article 13 of the proposed directive, European Union Speak for Law. It seeks to make internet services that host large amounts of user-uploaded material responsible for policing their holdings to prevent copyright infringement. Until now, companies have been able to draw on the safe harbor protection in the European Union's e-commerce law, which online services enjoy when they are mere conduits. The new copyright directive would withdraw that protection for any service that optimizes content, which includes things like promoting, tagging, curating, or sequencing a site's contents, most major online services in other words. In the future, sites would have two options. They could enter into a licensing agreement for all the content uploaded by their users, although the proposed law does not explain how that could be done for fragmented markets where there is no single licensing body. Alternatively, all online services must prevent the availability on their services of works or other subject matter identified by rights holders. So in a sense, content ID. The original text from the European Commission speaks of using content recognition technologies to achieve that. but the other key legislative bodies of the European Union, the European Parliament, and the Council of the EU, each of which produces their own version of the proposed text, which are then reconciled in the so-called trilogue negotiations, avoid using this description. A recent version of the text from the European Parliament's Jury Committee says the implementation of measures by service providers should not consist in a general monitoring obligation. That change is because critics pointed out that the European Union's e-commerce law specifically forbids European Union countries from imposing a general obligation on providers to monitor the information which they transmit or store. However, there is no other way of proactively blocking any unauthorized copies before they are posted without checking every single upload against the list of copyright works, and that requires general monitoring. Alongside these legal issues, there are serious technical problems with the approach, which is the fundamental problem with the Content ID system. The volume of user uploads is such that the filters will have to be automated, but navigating the subtleties of copyright law, things like fair use, is hard enough for courts, let alone algorithms. Automatic systems inevitably make mistakes, and the risk of financial penalties means that they will be written to err on the side of caution by over-blocking material, which is exactly what's happened on YouTube with Content ID. This is likely to have a chilling effect on free speech in the region and on the European public use of copyright materials in the production and sharing of memes, parodies, and criticism. Public domain materials also likely to be blocked. The European Union recognizes that general upload filters will be onerous and intends to allow smaller companies to take down material retrospectively instead. European Union politicians have also started adding explicit carve-outs for things like online encyclopedias, Wikipedia in other words, in open source software developing platforms. But it's not clear whether the latter exemption would apply to GitHub, since it hosts some software that is not open source. Adding in such exceptions makes the directive text increasingly complex and hard to interpret, which is likely to lead to years of court cases trying to clarify its meaning. An important question is whether the chilling effects, implementation costs, and legal uncertainty that Article 13 brings with it are worth it. The answer is no. And then there is Article 11. The other highly contested section of the proposed law is Article 11. This is the snippet tax, which seeks to make companies pay when they use even short extracts of text from news publication, as is common today on social media and elsewhere. A myth-buster put out by European media companies speaks of unauthorized large-scale reuse of publishers' content, as if copyright does not apply to a newspaper. It does, of course, which means that publishers already have the legal means to pursue such large-scale unauthorized use. Extra protection for even the shortest snippets will impoverish the public sphere by discouraging the share of news. A technical solution to stop search engines like Google from indexing content on news sites exists in the form of the robots.txt file. The fact that publishers don't adopt the simple means to block search engines is because publications derive considerable benefits from snippets of their stories being listed in the search results. That was demonstrated when both Germany and Spain brought in national versions of the proposed snippet tax. Germany's law proved so bad for publishers that they gave Google a free license to index their publications. In Spain, the situation was even worse. In Spain, when it was mandatory, Google closed down the Spanish version of Google News completely. Traffic to Spanish papers declined as a result, with studies suggesting falls between 6% and 30%. And, of course, there's obviously more. But the point remains. It's an idiotic law. It's a way of censoring speech. It's a way of making it more difficult to spread news. It's policing the internet with automatic bots, which is an absolute nightmare to deal with. Like, think of it. A company like Google, which created YouTube, cannot police YouTube. Do you think the European Union has the capacity to do that? Or do you think every internet company has the capacity to create such engines? They don't. And that's the issue. That's the fundamental problem. And then, of course, you have Article 11, which is also another fundamental problem with the proposed changes. Great job on Europe. The way content works right now is in both Europe and in the United States and other countries, of course, is the safe harbor provision. You remove that, you destroy the internet as we know it. You destroy a lot of websites, you make it far more difficult to do business. And that's just part of the problem. And that's the problem in the European Union. What about net neutrality? There are some people who believe, well, we got where we are without net neutrality. No, we got where we are with net neutrality being more or less the status quo, even if it wasn't explicitly stated out. Net neutrality is the way the internet built itself. And net neutrality basically means that internet service providers cannot decide what content is and isn't permissible online. Killing it now, after they've throttled traffic, blocked traffic to certain websites, means that they can decide that. They had the power before, they just didn't use it. Then they got the wise idea to start using that kind of power, and that's when you had net neutrality regulations, net neutrality laws being proposed and adopted. What the FCC did in the United States kills those net neutrality rules, and certain states are trying to prevent that in some way or another. That's why it's going to be the de facto way content is being viewed on the internet, even if companies want to move away from it because they don't want to piss people off. So it's a really horrible decision that is being made. It only benefits the big internet service providers. Now, of course, there's other problems with content on the internet. There are search engines that are really biased. Obviously, Google has a lot of power that they shouldn't. But the solution isn't to kill net neutrality, because that just gives the ISP that kind of decision making, which they shouldn't have. The solution would be to force, say, Google, Facebook, Twitter, and others to not give preferential treatment, to not block certain content because they decide to. And that's the problem that exists with the internet right now. But killing net neutrality is not the solution by any means. And it's very foolish that some people believe otherwise. That's all I had to say on the subject, on these subjects. Costin here on Serious Gaming signing out. Don't forget to subscribe, like the video. Thank you all for watching, and if you like my content, please do consider supporting me via PayPal or Patreon.